Did they see Bryan in the kitchen, cleaning the kitchen in these gloves and bust in the middle of the freaking night over these? Is that what the defense is trying to tell us? Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged. Okay, so we went through a few of the documents in this video, mainly because I feel like there's just a lot to say when it comes to this case. And honestly, it can all be wrapped up with, it's been over 2 years and the state has yet to produce any DNA reports for the defense. And some people act like that doesn't matter because the state has said, well, we're not going to use it anyway. And they've said that for a super long time. And it's funny that it's okay for people to just be okay with the state being the one that didn't want to use the DNA all the way back to John Daniels. Again, I'm going to repeat, all the way back to John Daniels. Meaning all the way back to the search warrants for his apartment being signed for. The IgG information was asked to be ignored. And that's before Bryan even got back to Idaho after his arrest. I don't know how that's not sketchy to people that think Bryan is guilty and use it as a reason for that not to be sketchy. But it becomes sketchy whenever the defense is now wanting to suppress it. I don't really quite understand how you can think one way but not think it's strange the other way. Now, there's a few other documents that we still need to finish going over, and a lot of people are asking about this subpoena, that there's apparently a witness that the defense is asking to come forward. I don't know. Let's take a look. Okay, so we did go over this one right here at the bottom, and then, of course, this one. Now, they've also filed to exceed page numbers. It states here that they want to exceed the 10-page limit for their reply to the state's objection to the defendant's motion to suppress and memorandum in support of the IgG information. So they want to go past the 10-page limit. I don't understand why there's a page limit. I mean, I guess I sort of understand why there's a page limit, but whenever this is a death penalty case, why are you not allowed to argue with whatever the hell you possibly need to, especially with a case so lacking? Like, seriously, 10 pages? The IgG information is literally the only reason why there was ever an arrest warrant made in Bryan's name. I don't give a shit what anyone else tries to say. Now we have the first of, I believe, 5 that are going to be exactly the same. I'm pretty positive these are all going to have the exact same argument to it. Yeah, the arrest warrant, the Idaho search warrant for defendant's person, Pennsylvania search warrant for defendant's person, search warrant for Washington apartment, and Pennsylvania search warrant for Hyundai Elantra. This is a reply for the following 5 motions, i.e. what we just read, and there's the VIN number for the vehicle. No arguments made and objections, thus no reply needed. So basically because the state didn't really argue much, they had a bunch of copy and pasted, very generic responses. They're claiming that there's nothing to argue is basically what this is. They're basically saying, go read what we said about the Franks hearing. That's all we have to say. That's basically what all of these are. Conclusion, Mr. Kohberger requests that this court suppress all evidence obtained by police via the arrest warrant, the Idaho search warrant for Mr. Kohberger's person, the Pennsylvania search warrant for Mr. Kohberger's person, the search warrant for defendant's apartment in Washington, and the Pennsylvania search warrant for the white Hyundai Elantra. Now, the one specifically for his parents' address is a bit different. It says, comes now Bryan C. Kohberger by and through his attorneys of record and respectfully submits the following reply to the state's objection to his motion to suppress and memorandum in support regarding Pennsylvania search warrant for 119 Lambsden Drive, Albrightsville, Pennsylvania, and statements made. First, it appears that the parties are in agreement on much of what law applies to the search of home. Several topics Mr. Kohberger addresses are more fully developed elsewhere, and his replies to those will be filed in his other replies, i.e. Frank's, IgG, Apple, Amazon, and AT&T records. That leaves the issue of how federal and Pennsylvanian law enforcement conducted their raid. The state tries to draw out its facts section by restating things several ways on pages 6 and 7 of its objection, but it basically just boils down to, we knew he was in there and owned a gun. But again, he went for runs every single day by himself, unarmed. So they must know somehow or another, that he didn't have it like concealed or something somewhere for them to state that. I mean, they could just be going off of what he's claiming. Okay, they could be. But he was running around out in the wild, in the neighborhood every single day for like the whole 2 weeks before they arrested him. But it basically just boils down to, we knew he was in there and owned a gun, which of course is true for most Americans. Yes, it is, me included. The state cites not a single case similar to the facts here. Instead, the state relies on a memorandum written by Police Sergeant Lang of the Pennsylvania State Police, apparently to justify their actions. This odd document, never before disclosed, appears to have been written in response to Mr. Kohberger's briefing and includes no date. So a mystery document? When did they get that? Because they're stating never before disclosed. So when did they get it? Ooh. Basically, the police tell us they had to destroy the house to save the car or some other evidence from Mr. Kohberger's rubber gloves. No legal authority is provided. What the shit? Let's reread. Basically, the police tell us they had to destroy the house to save the car or some other evidence from Mr. Kohberger's rubber gloves. Oh, because they're claiming that he had gloves on in the kitchen and was sorting through trash. At least that's what they claim with no body cam. Yeah. Had to destroy the house to save the car. Wow, okay. However, given that this statement now exists, the court can compare this scenario with any number of cases. Just a couple of examples. And we talk about the U.S. versus Gaither from 1994, forcible entry upheld, where police loudly announced but could hear sounds consistent with a constructive refusal? What the heck does that mean? And the subject was suspected of murder and believed to be well armed. What is constructive refusal? Is like that literally just somebody stating, no, I'm not coming outside? These agencies also recognize a constructive refusal to deal, which is generally characterized by the dominant's firm offering to supply its rival on unreasonable terms, such as extremely high prices, degraded service. What? So I put in constructive refusal in crime, and it gives me the exact same thing in criminal cases. Is it going to give me a different term now? Affirmation of constructive possession in criminal weapons cases. Okay, well, I'm not really quite sure, you guys. So if anybody that knows stuff about law stuff knows exactly what this means, to me, it sounds like the guy's not coming to the door or not doing what he's told, and they know that he has a weapon. That's what it seems like. Carnegie versus Cunningham from 1997, no-knock entry found unjustified, where a suspect was suspected of murder. The murder weapon, a handgun, was missing, and he had a history of drug dealing and violent crimes. Here, the police were concerned about making a hasty knock and announce, which apparently meant no knock and yelling from their Bearcat, because Mr. Kohberger was wearing the same gloves millions of homeowners wear to do the dishes. So he wasn't wearing latex gloves. If that's your... Okay, if they are alluding to the types of gloves, you know what? I think I might have some. Are they talking about these? Are they talking about these from the freaking dollar store that people buy to wash their dishes with? Because these are the types of gloves that normal, everyday Americans buy to wash their dishes with. 90% of people have these damn gloves in their kitchen. Did they see Bryan in the kitchen, cleaning the kitchen in these gloves and bust in the middle of the freaking night over these? Is that what the defense is trying to tell us? I don't know how they think they're going to get away with trying to tell us that there's no body cam, especially whenever we know there was multiple agencies. It wasn't just the feds. It wasn't just Pennsylvania State Police. Okay, there was several different agencies, so there's just no way. There's just no way. Plus, you know what? Has anybody ever asked or thought about if the Kohbergers have security cameras that might have picked all this crazy shit up, either in or outside? I have inside and outside cameras. Okay? So, did we ever find that out? If they had cameras? I'm going to need to go look. But you can't always see cameras. Sometimes they're hidden really well, and you can't tell. But I'm going to go back and look and see if they had any noticeable cameras. Two more things of note. According to the police, they had snipers watching Mr. Kohberger go from room to room, obviously greatly reducing his chances of posing much of a threat. And although the state oddly claims it is not true, the FBI had been surveilling Mr. Kohberger since December 21st and had many occasions to take him into custody. But that's weird to us, December 21st, because December 16th is whenever people went into the CVS and got his information, isn't it? Wasn't that the 16th? That's 5 days before the Fed started surveilling. That don't add up. And had many occasions to take him into custody. I mean, yeah, I agree on that part, but I'm still a bit confused. So what did the feds do? Tell Pennsylvania to start looking at him beforehand? See, these dates, bro. The state had identified Mr. Kohberger on December 19th, 2022 through investigative genetic genealogy. The state identified, okay, but why am I even more confused? We've been told the entire freaking time that the feds are the ones who came in and took the case from Othram, meaning that the feds are the ones who did the IgG work. Or did the feds take it from Othram and then give it off to somebody else, and we don't know who that person is? Entity is. Because the state identifying the IgG does not add up to me. I'm sorry, it does not add up to me. The state had obtained aerial photographs of the Kohberger residence on December 21st, 2022. The state had driven by the Kohberger residence on December 23rd, 2022, and followed Mr. Kohberger on December 24th, 2022. Cameras were placed on his parents' property on December 25th, 2022, and trash was taken from the property on December 27th, 2022. That date's the only one that sounds right here. And by the state, I don't believe that they're talking about Idaho here. I believe they're talking about Pennsylvania. Because the next paragraph starts with, the state seems to accept that a failure to abide by law as to knocking and announcing leads to the exclusion of what was found in Mr. Kohberger's parents' home. This court must suppress this evidence. I'm really confused. This document is honestly slightly confusing to me. Because to say that the state identified Mr. Kohberger on December 19th through the IgG, it makes it sound like it's the Idaho State Police. Because that would be the investigating agency. But then the warrant and getting into the house, that's the state of Pennsylvania. But if the state sent it to Othram, and Othram was told to stop what they were doing, and everything was given over to the feds, then how are they stating that the state's the one that identified him on the 19th? I'm confuzzled. Now, this one is for the Amazon account subpoena that was apparently used in the grand jury and for warrants that are dated April 26th and May 8th of 2023. Comes now Bryan C. Kohberger by and through his attorneys of record, and hereby submits the following reply to state's objection to his motion to suppress and memorandum in support regarding the Amazon account federal grand jury subpoenas and warrants dated April 26th and May 8th of 2023. As with other motions to suppress, the parties both provide fully developed arguments on some issues contained in the original motion in other briefs, which for the sake of brevity will simply be incorporated into this one. Those dealing with other search warrants, Franks, and IgG in this case. The main issue in this particular motion to suppress was the third-party doctrine. Disappointingly, the state provides little of substance in its objection to Mr. Kohberger's argument regarding the doctrine, its future, and how it currently exists within the Idaho Constitution. However, the state does make a somewhat interesting point about the differences between how this investigation might have looked before the digital age on pages 4 and 5 of its brief. In essence, the state argues that the internet does not matter, it is the act of shopping that controls. It's kind of a strange... The state argues that the internet does not matter. It is the act of shopping that controls. Okay. This sort of thinking is precisely what the United States Supreme Court rejected in Carpenter versus U.S. from 2018 and Riley versus California from 2014. The genie is out of the bottle. In the past, police would not have investigated every store that sells knives in the United States. They might have, given the sheer quantity of police involved in this case, covered a tri-state area, but time and cost would have prevented them from a massive search. Now, thanks to the wonders of the internet, the police were able to issue subpoenas and warrants to no small number of massive knife retailers, meaning the ones that we're seeing online are not the only ones that were submitted, which, like, duh. But then again, I don't also understand why, if they submitted more to more stores than what we're seeing, why not just post all of them? Why not publicly post all of them instead of just like the ones select few? It's kind of weird. One of those online retailers is Amazon, whose presence nationally and internationally does not need recitation here. The upshot, the police can now issue warrants to far fewer corporations. In other words, investigating shopping today is like shooting fish in a barrel, meaning the internet made it a lot easier to find what you're looking for when it comes to finding a suspect and where they got their weapon. This is why the third-party doctrine must be re-examined at the national level. If we the people do not wish to live under the ever-present eye of the government, something must be done. In Idaho, Mr. Kohberger's argument is that the something has already been done. It lies within State versus Thompson from 1988 and Idaho's protection of privacy. The court should hold the results of the subpoena and warrants to Amazon must be suppressed. Okay, let's see if Apple says anything different. And again, they are making sure that the title shows that it's for the grand jury subpoenaed information, which is also really interesting because, again, we were told by Logsdon that at least 6 people from the grand jury asked for more information because what they had was not impressive. What they had been shown was not telling them what the state wanted them to hear. And they were told there wasn't anything else. And that's extremely important here. Securing a search warrant after seeking privately protected information with a federal subpoena does not rectify a search in violation of the Fourth Amendment to the United States Constitution or Article 1, Section 17 of the Idaho Constitution. The words proof upon oath are not synonymous with the affidavit for search warrant is hereby incorporated. A non-particularized general affidavit in support of a search warrant held in the hands of law enforcement, which never accompanied the electronically served warrant, cannot be relied upon to validate a warrant. All contents of the Apple iCloud must be suppressed. Argument: the contents of the Apple iCloud are privately protected information, not protected by the third-party doctrine. In comparison, that dialing a person's phone number is akin to a copy of the contents of an Apple account is inaccurate. An Apple or iCloud account is a copy of a cellular phone, iOS, or other device. Without the information obtained by the federal grand jury subpoena, the state did not know what Apple and or iCloud accounts were associated with Mr. Kohberger to seek with a search warrant. So they didn't have that information? Or she's saying the only reason why they even knew is because of the federal grand jury stuff, I guess? All they knew was that there was a receipt for an iPad purchased in 2018 in his car, which again is kind of strange. I'm just going to put that out there. Nobody is keeping a receipt in 2022 for an iPad that they bought back in 2018. I mean, I'm a couponer, so I get all, keeping receipts. Plus, there's a lot of, tax deductible things that I keep receipts for because, adulting. But an iPad from 2018 to keep that receipt, I mean, it could have just been in there because he just never cleaned it out. And it, just so happens to also maybe match the one that was in the living room that they apparently never touched because for some reason they never touched it because I think they said it was in a general area. So there was no actual proof that it was his. It was just it could have been anybody that was in the houses, including, his parents. But this is interesting because it does make it sound as if Moscow, Idaho, in general, only had this receipt from whenever he was arrested. This odd 2018 receipt. that was in his car 4 years after he bought the iPad. I'm sorry, that's just odd to me. That's just really, really strange. To collect the records that law enforcement requested from Apple, it had to have a valid warrant, and that valid warrant could not rely on records obtained with a federal grand jury subpoena or a search warrant that recklessly and intentionally omitted material facts. The Supreme Court observed in Katz versus United States from 1967 that the Fourth Amendment protects people, not places, and finding the Fourth Amendment protects a person's conversations, and that a physical intrusion into the area a person occupies is not necessary to a constitutional violation. A party has standing to argue a violation on Fourth Amendment rights if his reasonable expectation of privacy has personally been infringed. And they mention United States versus SDI Future Health from 2009. Through the use of federal grand jury subpoena, the state learned that the Apple iCloud accounts searched were registered to Mr. Kohberger. Mr. Kohberger's expectation of privacy in these personal accounts is objectively reasonable, which establishes his standing to challenge the search and seizure of those accounts under the Fourth Amendment. And also, I just want to put out here, let me just put this statement out here right now for those of you who are still listening this far into the video. Them asking for this to be suppressed does not mean that there's anything that could harm him in this case. Because what else have we also heard? That out of 67 different devices and other things related to that, like platforms, social media, websites, etc., that were searched, there's no reports. There's no reports showing any evidence that was actually taken from those devices, from those website searches, from those social media platform searches, from those username searches. There's no reports the state has given over to the defense as of the documents that we went over in that last video. So, them wanting to suppress this stuff basically is literally only because you violated the crap out of his privacy, because you found nothing in it that put him in the middle of this crime, that put him in your target as being a suspect. And here's the proof, because you have all of these things listed, but it's all empty. There's no evidence reports. There's no DNA reports. Only 5 of your experts even have anything attached to them, and it's all completely useless. So them wanting to suppress this is literally nothing but you invaded his privacy and broke his constitutional rights. Yep. The warrant was general, and the affidavit was not incorporated into the warrant or served with the warrant. The Fourth Amendment to the United States Constitution states, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." Article 1, Section 17 of the Idaho Constitution is virtually identical to the Fourth Amendment, except that oath or affirmation is termed affidavit. The Supreme Court has acknowledged that a court may construe a warrant with reference to a supporting application or affidavit if the warrant uses appropriate words of incorporation and if the supporting document accompanies the warrant. And then it cites Groh versus Ramirez from 2004. In SDI, the Ninth Circuit held that a statement on the face of the warrant noting the supporting affidavit or affidavits was sufficient as a suitable reference and incorporation. The warrant contained no language that the affidavit was incorporated. The process described at pages 5 through 6 of the state's objection lacks proof that the affidavit of search warrant was provided to Apple. The state indicates that the investigators necessarily had copies of the affidavit in their possession when they executed the warrant by emailing it to Apple. See objection page 5. Further, the state offers that the effect of this is that the affidavit for search warrant and appended exhibit A cure any supposed deficiencies in the naked warrant, and then states to see the objection again. An officer sitting at a computer executing a search warrant by emailing it to Apple and having an affidavit of search warrant in his hand is different than an officer being physically present when executing a search warrant and having the affidavit for a search warrant available for reference. For example, transmittal email to Apple that the affidavit for search warrant and appended exhibit A was either attached to the search warrant or emailed to Apple as a separate document along with the search warrant. The August 9th, 2023 affidavit of Detective Brett Payne, corresponding to the return of warrant, has no indication that the affidavit of search warrant with the appended exhibit A was provided to Apple along along with the search warrant. And then it says to see Defendant's Exhibit E and tells you where to look. To the contrary, the sworn document states the warrant was served by Corporal Payne on August 23rd to law enforcement at apple.com. Whereas supporting affidavit does not accompany the search warrant at the time of execution, the details set out in the affidavit does not cure any deficiencies. And they cite U.S. versus Pilling from 2024, an Idaho case. An affidavit is considered to be part of a warrant and therefore potential curative of any defects. Only if 1, the warrant expressly incorporated the affidavit by reference, and 2, the affidavit either is attached physically to the warrant or at least accompanies the warrant while agents execute a search. And I don't remember seeing anything like that. Like with Don Daniels stuff, we have the attachment of Blaker's probable cause affidavit, like attached to everything with Don Daniels' search warrant paperwork, where she writes out her summary of who she talked to, what she's been told about the case, and also where she writes to ignore the IGG information. Let's just do that daily reminder. And again, like I've said a million times, this is also where we have in her own words asking for the court to ignore the IGG. And we also have in her own words all of the supplemental narratives that she attached when it came to the fact that she misplaced DNA evidence for 10 days. But they are right. When it comes to all of the search warrants that we, the public, have been able to see on the Idaho Case of Interest site, there's nothing attached to them. It's just all of the paperwork for the search warrant themselves. There's no affidavits, there's no probable cause, arrest warrants, or anything else. There's nothing attached to it. So it is almost like they're asking for information without giving probable cause for needing it, just stating that we think that it might be in there, but all of the other information that should be attached is not there. The search warrants fail to provide specific particularization of what to search for and separate any production that was not related. We've gone through this argument already. Basically, they're saying that it wasn't specific enough. And my question was, what is it that they expected the warrants to state? Especially when it comes to, like, let's say the phone stuff, okay? Are they expecting it to say any correspondence between the suspect, Bryan Kohberger, and Kaylee Goncalves and or Maddie Mogen and or Xana Kernodle and or Ethan Chapin and or Dylan Mortensen and or Bethany Funk and or anyone else related to the victims of the homicide that took place at 1122 King Road? Because they did say anything that could be related to the homicides at 1122 King Road. And at that point, let's just be for real, they didn't know what the hell they were looking for. But that's why they're going back forever and ever to stuff that doesn't even have anything to stand on. But that's basically what this argument is right here. So let's see if there's anything specific in it. The Fourth Amendment requires particularity. The particularity requirement's objective is that those searches deemed necessary based on a probable cause determination by a magistrate should be as limited as possible. And that does matter because this is how far back they went. October 7th of 2016 to December 30th of 2022. Now, why they chose this date, I don't know. Maybe that's whenever his very first ever Apple account was birthed, was October 7th, 2016. I don't know. But they went back. Look how far. For what? Because they needed to try to find enough because they had nothing. And they figured that if they cast the net out into a big enough ocean, maybe they'll catch a few bait fish. Not only did the state obtain the entirety of Mr. Kohberger's Apple accounts, or 13.3 gigabytes of data, and they are validating that there is more than one, which we've already established from a few videos ago, especially. We've talked about the multiple numbers, and we've talked about the possibility, but it has been definitely validated that there is more than one Apple account. But that's also, apparently, according to every one of you guys that watch these videos, have said that that is completely normal to have two Apple accounts, sometimes even more than that. Like each individual device sometimes has its own Apple account. Even things that shouldn't have phone numbers have their own like phone number because it's an Apple device. I am a Android person. This stuff is just way too complicated for me. But this is interesting right here because out of all of that 13.3 gigabytes of data, the state has taken no action to sort through that which is lawful or applies to the charges. Do they know that? Because there's nothing attached in the reports that shows what kind of evidence was actually taken from the devices and the other likenesses that they searched. Those 67 that we talked about in the previous video? Maybe. It has produced the warrant return without any analysis whatsoever. Again, that's exactly what that statement means. It has produced the warrant return without any analysis whatsoever. So it says they took all this data, but whatever they found on it, nothing relevant enough to the case to be attached. They're not showing the defense that they have found anything. 13.3 gigabytes of data from multiple accounts, and the warrant returned without any analysis whatsoever. They literally have nothing. They have literally nada. The fact that an Apple account is sought because it may hold some of the objects of the proposed search does not automatically give the state authority to seize every file, photograph, or text that ever touched the account. Instead, the balance between the government's interest in law enforcement and the right of individuals to be free from unreasonable searches and seizures of electronic data must be determined on a case-by-case basis. And it cites a United States versus Cheso from 2013. The Apple search warrant was not supported by probable cause to search and seize everything listed. There were absolutely no limiting standards included at all, and the state could have particularized the warrant to specific dates and items that would be evidence of the specific crimes. The Apple search warrant did none of that. This result is worse than that in piling because no separation of data was even attempted, leaving 13.3 gigabytes of data without any analysis about what the state intends to use as evidence. Again, I know we just read that exact same statement, but I am still just flabbergasted. 13.3 gigabytes, and they haven't mentioned not a single shred that they have found that they plan to use as evidence. They have like less than nothing. I mean, is that even possible? Can we get into the negatives when it comes to this kind of situation? Because for real, the state has rummaged through it all. In piling, the prosecution narrowed the Apple data to 9 documents. The court suppressed, as it must here. I mean, but honestly, what are you suppressing at this point, though? Because if there's nothing there, if the state is just like holding on to it and they've gone through all of it, but they found nothing to list on the analysis reports, then what are we suppressing besides the fact that it happened in the first place? I mean, it really, at this point, this argument is based on principle and principle alone. The affidavit submitted in support of the application for the issued search warrant recklessly or intentionally omitted material information. In response to the state's argument, under defendant has not demonstrated the search warrant affidavits contain intentionally or recklessly false statements or omissions. Defendant refers the court to and hereby incorporates defendant's replies in support of, okay, so go see the thing for the Franks hearing and the IGG. Conclusion. Mr. Kohberger requests that this court suppress all evidence obtained by police via the subpoenas and warrants that permitted them to search Mr. Kohberger's Apple and iCloud accounts based on the simple fact that it happened and nothing more, because they have given the defense not a single shred of evidence that they intend to use, meaning that through all 13.3 gigabytes of data, they found absolutely nothing to use against him as evidence in this murder case. Nothing. Hey, hi. So what happened was that somehow, even though I did not get up from my desk and I did not change any settings, there was a portion, like a 16-minute portion of my recording where the microphone like slipped into my headset microphone instead of my condenser microphone. I don't know how. Because you'll see that like the me from a second ago is also the me that ends this video. So I don't know what happened. So I'm going to go ahead and record that part now. Here we go. So the AT&T first warrant was next. And like I mentioned, everything in here is going to be pretty much 95% copy and paste the exact same information with little sprinkles sometimes of specific information for the specific warrant. It talks about how it's not particularized and how it goes against the Fourth Amendment. And it also talks about how the affidavit, just like in the other arguments, none of the affidavits and none of the exhibits are attached to anything. It's just, we basically got this information from this other police department, and now because of this investigation and what they told us, we need this information, but none of the supporting documentation is included. And it ends up ending the exact same way. Now we have the USB for the cell phone. Now this is one of the ones that I still find odd because they're getting a search warrant to get information from their own lab, Moscow Police Forensic Lab. And this is apparently the USB that is the forensic download that the FBI apparently are the ones that got from his cell phone whenever he was arrested in Pennsylvania. But one of the other things we also need to remember here is that one of the first things we ever heard coming from Bryan's camp was from this attorney that he had in Pennsylvania. And he was quoted as stating that the GPS information on Bryan's phone was going to prove that he was innocent. And that apparently was said to him by Bryan. So interesting enough as it is for where we are now in this case. And even though I agree that all of these documents should follow every protocol and have all of the things attached and be very specific and all the things, okay, I still find it weird because why is the Moscow Police Department having to put out a warrant, a search warrant, to get information from their own lab? Like, if it's already in their possession, why do they have to get a search warrant for it? I guess that's the part that's confusing. Like, I know that the feds are the ones who apparently created the USB, downloaded the information that's on the USB, but if it's already at the lab, why are you having to ask yourself for it? And again, it's going to be the exact same arguments. And then it says the affidavit of Detective Lawrence Mowry swears he personally served the warrant at the Moscow Police Department Forensic Lab. See Exhibit A for cell phone memorandum. Further, the receipt and inventory of the warrant indicates that entrance was by Key Computer Forensic Lab. Neither the affidavit nor the search warrant mention that the search would be conducted by a third party. Rather, the search warrant was directed to the Moscow Police Department Forensics Lab. While the supporting affidavit might have been in hand during the search as asserted in the Incorporated Apple objection, there was no language incorporating the affidavit into the search warrant. Further, there was no language in either the search warrant or the supporting affidavit authorizing the search by a third party. After the return of search was produced to the magistrate, an order issued allowing a third-party search. There is no evidence that the third party received a copy of the affidavit in support of search warrant. So no matter where this thing went, they just technically didn't attach anything to it, including the PCA, which you'd think that that would be like number one at least when it comes to attachments, because at least Dawn Daniels had that. She had Blaker's PCA attached to all the stuff for the apartment. And again, with it failing to be particularized and it going against his constitutional rights, and it ends the exact same way. Now we have the one for Google. And again, it starts exactly the same, and it actually has the Fourth Amendment of the United States Constitution in this one. So I'm just going to go ahead, blow it up big on the screen, and read it in its entirety. The Fourth Amendment to the United States Constitution states, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." And again goes on to state how the Idaho Constitution is basically the exact same thing, except that oath or affirmation is termed affidavit. And then it's the same argument until we get here. The affidavit of Detective Brett Payne swears that Detective Mowry served the warrant. See Exhibit D for the Google memorandum. The email between Mowry and Google reference a warrant. See Exhibit F of the Google memorandum. No return documents reference the affidavit in support of search warrant as having accompanied any of the Google warrants when they were served. Nor does the state produce such records in its objection. So even after the defense has already made it clear what they think is missing, what should be where it's not, the state is still not being like, oh, we just forgot to attach it, here it is. Or, hey, we forgot to show you this copy of this, here it is. We actually have exactly what we're supposed to have, just for some reason it just didn't get sent over. None of those things are happening. If anything, they're showing with every single one of these requests that they have less and less than we actually thought, which is saying a lot. But then it continues on with the argument, calling it a naked warrant. And again, with the particularization, the fact that the Google accounts are sought because they may hold some of the objects of the proposed search does not automatically give the state authority to see if every piece of data that ever touched the accounts between January 1st of 2021 and December 30th of 2022. Instead, the balance between the government's interest in law enforcement and the right of individuals to be free from unreasonable searches and seizures of electronic data must be determined on a case-by-case basis. And ends with the exact same argument. Now, the only thing that's additional for this one is that they've added the United States versus piling or pilling from 2024 that they've mentioned a whole lot so far in these documents. They've referenced it quite a bit. And this is the portion that they have highlighted. Second, the supporting affidavit apparently did not accompany the Apple warrant at the time of execution. Consequently, as in Spilatro, which is, I guess, a different case, the significant details set out by Agent Byrd cannot cure the generality of the warrant. So this is giving the example of what was missing and what the issue was in this case that matches the problem that we now have at hand in this case. So now on to the pin, trap, and trace device. It's going to be the majority the same until about right here. In this case, no such words exist in the warrant. The affidavit nor any of its exhibits were incorporated, which is the same argument for literally all of them. On page 3, in reference to the installation of a pin register and or trap and trace device, there is language that states, the court finds that Brett Payne, investigating officer, and Ashley Jennings, senior deputy prosecutor, has certified to the court that the information likely to be obtained by such installation and use is relevant to an ongoing criminal investigation. While this language is unique to the trap and trace warrant, it does not incorporate the search warrant affidavit or any of its attachments. So there's no other warrants that have Ashley Jennings' name on it? I'm going to have to go back and take a look. The affidavit of Brett Payne swears that warrant was served on 12/23/22 by sending to FBI for service. And this is Exhibit A, and there's a footnote 1 to reply in support of defendant's motion to suppress a memorandum regarding the pin, trap, and trace. It will be filed under seal concurrently with this reply. It goes on to say an FBI form similarly reflects that a prospective location tracking search warrant that included a pin register / trap and trace for telephone number 509-592-8458 on behalf of the Moscow Police Department was served on December 23rd of 2022. On or about December 23rd of 2022, an AT&T mobility carrier request form was completed. Attached to the AT&T form is the pin tap. Is that supposed to be trap? Pin, trap, and trace search warrant at issue. The affidavit in support of search warrant not included. So just, they're not attaching anything. The return documents, the FBI form, and the AT&T form do not reference the affidavit in support of search warrant as having accompanied the pin, trap, and trace search warrant, nor does the state produce such records in its objection. So again, the state's very aware, and they're not doing anything to alleviate the issue, probably because they can't. But then again, if it's their own PCA, then this is really just them not really doing things like they should, I guess. And then it goes out and it closes the exact same way. But in this one, they actually have the search warrants, and I'm pretty positive these are all our search warrants that we've already seen. Okay, this part's a bit different. The rest of it is on the public interest site here, way up at the top. This is different, okay? Okay, so what we are about to go through is something that I have never seen before, and this is genuinely me not seeing it before, meaning the first time I ran through these documents, I did not see this. So I don't know if I genuinely missed it and somehow didn't realize that the page kept going, which I highly doubt because you scroll to the bottom of the page and then the page just doesn't go anymore. It's done. So I don't know. I don't know if this somehow got scanned in afterwards or if I genuinely missed it. But I honestly don't even know if this is supposed to be here. I don't know if this attachment is supposed to be public. It doesn't look like anything we've seen. We've seen really nothing from the feds, and this is written by a fed. I don't know. All I know is that I did not see this the first time through. Unclassified Federal Bureau of Investigation. Date of entry is 2/24 of 23. So this was written on 2/24 of 23 by Nick Balance. We've heard that name before in this case. Okay. On December 23rd, 2022, the Federal Bureau of Investigation served a prospective location tracking search warrant that included a PIN register / trap and trace for telephone number 509-592-8458 on behalf of the Moscow Police Department. The information captured as part of this legal process is being attached to the 1A section of this serial. And here's the whole form. Okay, so this is the AT&T mobility carrier request form, and it's the Salt Lake City office requesting the trace. Criminal court order, new activation. Docket number just says CR29 and then it's blanked out. But that's like a number that's for everyone to know. So I don't know why you just did that. Oh, okay. Telephony, text message with cell site location, packet data, Wi-Fi. Call detail records from 6/23 of 22 to 12/23 of 22, along with cell site location. I don't know what this means right here. PC, MD, RTT, TrueCall, and Nelos, and also subscriber info. And then send the records to njbalance@fbi.gov. GPS ping for 12/23 of 22 to end on 2/23 of 23? Every 15 minutes. So they're pinging his device every 15 minutes for 2 months, even after they've arrested him? Is that what that means? Because I don't know. That's kind of crazy. Okay. Non-disclosure order included. Oh, so there wasn't a non-disclosure order or any sort of gag order whatsoever on 12/23, but I'm pretty positive just off the top of my head that by 2/24 of 23 we had that gag order already. I don't remember exactly whenever the madness started, but this was written up on 2/24 of 23. Additional contacts. And then I guess this is part of the rest of it and the non-disclosure order. Okay. 1122 King Road. Okay, so this is the, I guess, vague wording that they're talking about, okay? Brett Payne, having given me proof upon oath this day showing probable cause, establishing grounds for issuing a search warrant, and probable cause to believe there are records related to the crime or crimes of homicide at 1122 King Road, Moscow, Idaho, and are currently under the control of AT&T for historic call detail records for the telephone number of 509-592-8458 with cell sites for all voice, SMS, and data connections between June 23rd of 22 to present, which to include subscriber registration info, device identifying information, usage and location, cell site, physical address of cellular antenna, and subscriber identity. And then you have 14 days to give us the information that we are demanding of you, basically. Yeah, this is like the regular formatting of like, this is what we expect of you because... But then they give them this long. See, all this stuff being written out in February is like bothering me. It just is. It's just super bothering me. Now, the 20th supplemental request for discovery is under here, but we actually went over that already. As usual, it's sealed. It just gives us an exhibit with a letter and no further information. And of course, the state has already responded in their generic freaking response that they always do, where they just name every single request for discovery that they've received thus far, and then acts like they're actually doing their job in responding to those with actual evidence. This one I just find sort of useless and pointless because I thought we were already doing this. Stipulated motion to file defendants... Oh, come on, guys. The D is missing. Replies to state's objection to Frank's and IGG under seal. Comes now Bryan C. Kohberger by and through his attorneys of record and with a no objection from the Latell County Prosecuting Attorney's Office, and hereby moves the court for an order to file their reply to the state's objection to the defendant's amended Frank's memorandum and their reply to the state's objection to the defendant's motion to suppress and memorandum in support regarding the IGG under seal. I thought we were doing that already. Wasn't that established a long time ago that everything pretty much was going to be under seal? The stipulated motion is made pursuant to ICAR 3212D and E and IC 74-1241B and C because they are either previously already sealed or are redacted. Duh. The under seal reply and exhibits are being provided to opposing counsel and court staff via email on the date of this motion. Hand delivery to the court for an in-person filing will occur on December 20th, which means this happened a long time ago already. Again, duh. Like, I thought we were doing that. Why did we have to do all of that? Okay, now, to this one. We still to this day, and right now, finishing this up, it is Friday, January the 3rd at around 5 p.m. But we still to this day don't know what the hell this is, okay? There are so many people out there guessing, and that's fine and dandy. I'm going to give you my guess right now. I think that the defense is calling somebody from the state's expert witness list that is integral to the case, extremely, extremely important to the case, but that has not presented any information. And if we're going to be completely honest with ourselves about the biggest elephant in the room when it comes to this case, I think it's whoever the DNA expert is that the state listed that gave no opinion. I think that the defense is calling one of the state's expert witnesses, and I think it's the DNA witness. I think it's whoever the expert was who worked on the DNA. There's my bet on what this is. Now, that's if this is an expert witness subpoena, which I'm pretty positive that it is, because the entire definition of a subpoena ducis tecum is a subpoena for the production of evidence. So while I have seen a few people thinking that it might be Dylan or it might be Bethany, this is definitely going to be an expert witness. Now, this is more of a blank form to me, too. This doesn't look like something that they wrote on and then did a great job whiting it out. I think that this is just a form that has the date for the court case in it. This could have honestly been sent to more than one person. This is just a form that we're seeing. So it could be more than one. It says, you are hereby commanded that, laying aside all excuses, you appear in the district court of the 4th Judicial District of the state of Idaho in and for the county of Ada and Boise, Idaho on January 23rd of 2025 at 8 a.m. through the end of the hearing as a witness in the above entitled matter on the part of the defendant. You are further commanded to produce or permit inspection and copying of the following documents or objects, including electronically stored information at the place, date, and time specified above. The subpoena may be complied with by providing the requested documentation to the office of Ann Taylor prior to the above date, and then she gives her contact information. Meaning, whoever this person is doesn't have to actually show up and physically be in court if they hand over the documents before the court date. That's another reason why I'm really wondering if it's like the DNA witness, because them having nothing at all when it comes to the devices handed over when it comes to evidence analysis, that's one thing. But for them to have literally no opinions, no reports, no nothing when it comes to the DNA after all the drama, nah, they better be calling the state's DNA witness. That better be what this is. Wow. Yeah. There was a lot of information in these documents, a lot more than I thought there was going to be. Again, for a case with a gag order and with so many things constantly being filed under seal, we get so much information, but it just causes like more chaos. And yeah, the defense team does it too. Yeah. It's almost midnight. I did stop recording in the middle of recording this one to post this video about the dates because it was just tripping me out a little bit too much. The CVS 16th and the IGG naming him on the 19th. I know that they would never answer me because they never answer me, but maybe I'll email Ann Taylor's office and be like, hey, you want to like amend this, fix this, and make this make some sense? I'm not really quite sure what this means. Because, I mean, I'll admit, it could mean that he's seen on camera after the 19th. Like they've gone in and done more whatever on his phone to get his location to show that he was in Pennsylvania. But that's just a very confusing. He was observed going into the CVS on the 16th. Somehow law enforcement got his information. It makes it sound as if he was being watched. They went in after he was done and he left. And the clerk, the person behind the register, just typed in whatever they got to type in to bring up the previous transaction. Or maybe he actually walked out with like a prescription and they walked in and went to the pharmacy and asked for the previous person's information. I mean, I know they're not supposed to just willy-nilly give it over, but I mean, we talked about this statement previously, and it's just still kind of blowing my mind, these dates. And then the fact, 13 point something gigabytes of information. You haven't laid out a single shred of anything that you have found in all of that information to use at trial. Like, that's why the state keeps getting all these freaking discovery requests, because everything that they're handing over is obviously blank. There's no attachments, there's no analysis reports, there's no opinion reports. It's been empty like this from the very beginning. We already see from what Mallory and Payne testified to on the stand, how disgustingly empty this case is, and they're like low level. They're the ones who ended up trying to pick up the pieces and reverse engineer this thing after the feds apparently did everything. But then again, now we're getting that story all kind of mixed up too. Because we were told this whole time, Othram was told to stop what they were doing and the feds did the IGG. Now in these documents, they're claiming that the state's the one that named Bryan from the IGG. That can't be. That can't be. This has got to be the most confusing drop of documents so far. I think, yeah. My flabbers are gasted. I am going to get off of here and take a bubble bath and start editing this tomorrow before work. Again, it is January 1st that I am recording this. But let me know what you guys think about all of it. Again, my flabbers are gasted, and I just need to go relax before my mind just melts and out of my ears. If you like the way that I present this information and give my opinion, please don't forget to leave a like on the way out, subscribe to the channel if you are not subscribed already, and please don't forget to make sure that your notification bell is set to all. You'll get a lot of this stuff earlier than it takes for me to get a whole video out because I'll post this stuff in my community tab so you can be in the know first before anyone else. So please do not forget to make sure that that notification bell is set to all so you don't miss any of my rants, reviews, reactions, updates, or deep dives. See y'all.